If we didn't do that, parties might learn which way their case was likely to be resolved. For example, in a civil matter, if someone learned they were likely to lose, they might, and the other side didn't know that, they might go out and arrange to settle the case, greatly to the prejudice of the party not privy to the leak that they'd received. Confidentiality is essential also after the case has finally been decided, because without it, a justice would be unable to freely debate the merits of the case with the other justices out of a concern that his or her views might be misrepresented to the public, among other reasons, after the case was finally decided. I think that in the interest of bringing the court back so all 7 justices are meeting at our conferences, that we need to put to rest the questions about this confidentiality rule. I believe it's in our interest not to debate about whether the rule's valid or not valid. Rather, I think we should expend our time and our efforts toward making sure we have a valid rule that we all can observe, and that if we can all observe that, then we can all meet together as we have in the past. And for that reason, I offer this amended version of AO 2006-08. And it's amended because this is the position that I've always taken on this, and the reason I didn't vote for it originally was because it didn't have this language in. This is my proposal. All correspondence, memoranda, and discussions regarding cases or controversies are confidential. This obligation to honor confidentiality does not expire when a case is decided. The only exception to this obligation is that a justice may disclose any unethical, improper, or criminal conduct to the JTC or another agency as appropriate, and to the general public. Is there
Support.
Okay. Again, this is offered to fill the flaw that Justice Weaver has identified.
I'd like to ask the chief a couple of questions about this. I'm not sure what to make of your vote on the prior order. You voted against Justice Weaver's motion. I did earlier read the language about the public hearing rule, which really doesn't have any requirement. You say it's been our practice, but it doesn't have a requirement that we vote a second time.
The requirement was in AO 1197-11B.
I read from that to you. If no public hearing has been held before a rule is adopted or amended, the matter will be placed on the agenda of the next public hearing, at which time the Supreme Court will hear public comment regarding whether the rule should be retained or amended. It doesn't require a revote.
Explicitly doesn't require it.
Okay, Justice Hathaway, would you like to point out where you're going with this?
Yeah.
Which,
She's reading 3, and there's no requirement of a second vote under 3. She's read that to
No, I
us.
think
I
she was
already
reading
put it on
something
the
else.
record. It says, I'm reading Administrative Order Number 1997-11, and this would be under B1. If no public hearing has been held before a rule is adopted or amended, the matter will be placed on the agenda of the next public hearing, at which time the Supreme Court will hear public comment regarding whether the rule should be retained or amended. 3, the adoption or amendment of a court rule or administrative order by the Supreme Court shall be by a recorded vote and shall be available upon request from the Supreme Court clerk.
there was
I think that requirement can be met by the initial vote.
right.
Right.
Well, they
And I
can
think
just
it's-
make, excuse me,
If the court does not amend or rescind, it's retained.
You're right.
That's my view.
well, let me ask you
There
this.
was no vote.
There was
Justice,
an initial vote.
Chief Justice, with no offense to you, I think you're out of order in what you've done today. There's been no notice to the public as to what, and an opportunity for public comment. The records of this court showed the file was closed. So now, I guess you're opening it up, you're making an amendment now. You didn't open up the file, you didn't give people notice that you were doing that. And I would think, and I suspect, the people of this state will be very interested to comment upon what you've done. Your change to it is irrelevant. It's the first sentence. It has done nothing but say that a judge can go. It doesn't answer my concerns that the whole rule, the first sentence of your rule, which makes it forever rule, is in conflict with our judicial canon, which says that all you have to do is abstain, and that's a voluntary action. It's interesting to me how interested my colleagues were about voluntary with respect to the lawyer's obligations to help the poor. But in this case, and I just question, what's the purpose of having the public comment to retain and amend if you're not going to vote on it? You didn't vote on it, the file was closed. Our court, there's no record of how it got closed. But the fact of the matter is now, you're just bringing this up, amending it, and not giving the public a chance to comment on it, of course, but if public comment doesn't matter, and this is just the 800-pound gorilla rule of this court, so be it.
With all
I
due
mean,
respect, if I have just heard Justice Kavanaugh properly, it doesn't seem to me that he hears that there's any issue with regard to 2006-8, since it was properly adopted in an emergency setting and the vote was recorded. Ergo,
I'm in agreement with that.
Well,
I'm in
Justice
agreement with the position that he just made, that 2006-8 stands. And frankly, I have no objection to your amendment, Chief Justice Kelly, whatsoever.
Well, as I said before, I don't mean to interrupt you. No. As I said before, I'm interested in bringing this to closure. And I
think you
thought
got
that
4
by...
votes for
well, I would like, to speak about
if
this
there's,
further.
and by all means you can.
Thank you.
But it's been my feeling that if a serious question is raised about whether this 2006-08 ever was properly passed, that we could close that gap by voting now on the rule, and I just made a small amendment to it. So that's why I brought it.
I
I'd
believe
like
4
to see
votes
us-
believe that the rule is effective now. If you want to change it, that's fine.
Would this amendment be an emergency?
It could be
There we go
treated.
again.
Yeah.
Yeah,
But
you're doing
let's
it.
adopt it-
No.
let's adopt it as an emergency, have